Welcome back to the channel, guys. Hope your preparations are going good and you're also doing very good. So this video is basically about your RTP about your September attempt, which is usually expected to bring in somewhere around at least 5 to 7 marks from your main examination. So we'll be going through this RTP September 2024 in a very brisk manner. So I'll not be explaining the complete concept of the question, but I'll be going through the questions in a very quick manner. I'll be completing the questions and I'll give you the suggestions on how to write these answers on a brief manner. So if at all you feel this is a little fast for your liking, so please make sure that you stop the video, get to the question, understand it, and then we'll move on to the next part. So starting with this, two major things I want to solve with this RTP, which is going to be discussed now, is first thing is people face a major difficulty on how to read the question. So how to read a question is one of a vital part of understanding a theory papers. So first we'll understand what your thinking process must be once you start understanding a question or reading a question. So without any further ado, we'll get into the concept. So this is the RTP, which is for September 2024 attempt, which is containing a total of 10 MCQs, 2 marks each, and then we have 10 descriptive questions. So in total we'll be having a total of 20 questions, 10 MCQs and 10 descriptive questions. So we'll get into this one by one. We'll start with the case study, the first case study. So try to read it alongside me and try to understand the thinking process which goes into understanding or reading a question paper. So look at the first question. Tejas Infra Limited was incorporated by Tejasvi Singh and his wife Meenakshi along with 7 other family members in the year 2001 with the aim to undertake infrastructure projects. As soon as I get across this word infrastructure projects, what clicks my mind is we have preference shares and debentures which are usually issued for. Preference shares issued usually for 20 years and debentures which are usually issued for 10 years. But when it is involving an infrastructure project, I can increase the number of years of 20 to 30 and also debentures 10 to 30. So first thing that clicks my mind, infrastructure projects, the tenure process, and they have clearly stated that they have 2 members along with their 7 other family members. So it is a public company having 9 members in total. So I'll write down whatever important terms I feel in the entire case study as and when I read the case study. So I have 9 members. I'll write it down that it is an infra project. If it is an infra project, there is highly likely that there is a question on preference share capital, preference share or debentures. Now continue the question. Infrastructure projects relating to transportation in the country. The company had successfully completed construction of roads, canals in Delhi, UP, Chandigarh, and rose to become one of the prominent construction companies in India. The register office of the company is situated in Konagat. So basically it's a place in New Delhi. I'll highlight that process. Register office is located in New Delhi with a capital base of 100 crores divided into 10 crore equity shares of 10 each. So it has a total capital base of paid up share capital of 100 crores. So that might be useful for me some case study. So I'll write out the important part. Paid up share capital of 100 crores. The company has 8 directors and out of which 3 are independent directors. So I have a total of 8 directors out of which 3 are independent directors. That is one of the other important points which might be a question. The company got new project from the state government of Punjab to build 4 flyovers and underpasses in different cities of Punjab. In order to increase its capital base, Tejas Infra Limited decided to issue 1 lakh preference shares of rupees 100 each to the existing shareholders. For this purpose, it has decided to increase the authorized capital by 5 crores dividing into 5 lakhs of 100 each. So they have increased their authorized capital by 5 crores and they wanted to raise a total of 1 lakh preference shares of 100 each. That means they are raising a total of say total of 100 lakhs. Sorry, 10 lakhs here. 100 lakhs, 1 crore. Then the project went off well and the turnover rose to a tune of 3,600 crores. So turnover of the company is now 3,600. And in the immediate preceding financial year, and the net worth of the company stood at. So net worth is also given 550 crores. As soon as I see the word net worth turnover, my mind clicks me the process of CSR, the applicability of CSR. Remember applicability of CSR based on section number 135 subsection 1. If any of the three limits are met, I have to apply CSR committee. Then moving on, as they crossed the threshold limit in the immediately preceding financial year, the board level committee headed by one independent director, namely Pratyosh. So I'll mention that Pratyosh is a independent director clearly so that I'll come back to the case study. Was constituted to allocate budget, review the process and provide guidelines on various corporate social responsibilities and sustainability initiatives. So basically we have established a CSR committee here. It was decided to spend the requisite amount towards skill development, vocational training, provisions of safe drinking facilities, etc. So all of these activities are basically part of your schedule 7, 12 category of items for CSR. Lokesh, one of the directors who is also a member of CSR committee, is in favor of Janta Andolan Manch, a political party. So political parties, as soon as I hear the word political party, any contributions towards a political party are not considered as a CSR. They are expenditure which are not CSR. So there might be a question on this. This party is quite prominent in undertaking social work. As per his advice, the board by a unanimous resolution resolved to contribute 5 lakhs to the said political party Janta Andolan Manch and to treat such contribution as part of CSR activity, which is not allowed because we have specifically mentioned that any political contributions are not a CSR activity. Now we are done with the question and we have underlined all the important concepts which might be a question for us. Now let's get into the questions here. From the case scenario, it is evident that Tejas Infra Limited decided to issue 1 lakh preference shares of 100 each to the existing shareholders. From an option given below, choose one which indicates a maximum period which is permitted to the company for redemption of preference shares. As we all know, whenever it is for infrastructure projects, as we discussed, it was for 4 flyovers. When it is for infrastructure projects, the company can raise preference shares under section number 56 for a period of 30 years, but the redemption of these shares must start from the 21st year at the option of the preference shareholder with an amount of an average amount of 10%. So I look for all these keywords: 21st year, 30 years, 10% at the option of preference shareholders. So looking at the options, first thing I see is they'll be redeeming it from 31st year. As soon as I see that, I'll cross it off. That is not an option for me. Second thing, redeeming from 26th year onwards. That is not an option. Then redeeming from, commencing from 21, this might be an option. Then the last option, they have stated that it is 26%. Now, to make sure that my answer is correct, because I have not read all the options, I have made an elimination process here. I'll go back to the answer which I think is correct and confirm the answer. Tejas Infra Limited, being involved in infrastructure activities, is permitted to specify maximum period of 30 years. That is one of an option, 30 years satisfied, for redemption of preference shares subject to a condition that it shall redeem a minimum of 10% of preference shares per year. That is also good. Commencing from 21st year, that is also the concept, or earlier on the proportionate basis at the option of preference holders. Basically every single point of section 56 is covered in option number C. Hence the answer would be option C. I hope this color is clear for you. Option, or I'll use another color. Option C. So answer will be option C. Moving on, second part. The case scenario states that the turnover of Tejas Infra Limited rose to a tune of 3600 crores and a net worth of a company stood at 550 crores in the immediately preceding financial year 22-23, which requires formation of CSR committee. What's the third criteria, which is if it crossed shall be required that CSR committee be formed? We know we have a total of 3 criteria under section number 135 subsection 1. That is your net worth of 1000 crores of more than equal to 1000, net worth of more than equal to 500, or net profit of more than equal to 5 crores. So I'll be looking in the options for this part, net worth of more than equal to 5 crores. So let's get into this. The third criteria which also requires formation of CSR committee is that the company's net worth is 2 crores. That's not the right answer. Then moving on, second question, second option, 3 crores. That is not the right answer. 5 crores is an option for me. 6 crores is not an option. So the answer will be again C. And third point, according to the third question, according to the legal provisions, it is mandatory to redeem preference shares at the stipulated time. Keeping in view the above case scenario, which source is required to be used by Tejas Infra Limited for the redemption? So we have two sources of redemption under section number 56 for preference shares. It states that we can either use the profits which are available for the distribution of dividend to the shareholders, that is basically your previous year profits reserves, or second option is fresh issue of shares. You can go for fresh issue of shares and the proceeds of that fresh issue of shares can be used for redemption of the preference shares. So going to the options here, the first option is Tejas Infra Limited is required to redeem preference shares out of the profits which would otherwise be available to dividend. This is an option. That is the right answer, but don't jump into conclusions. We'll go through all the options. The second option, Tejas Infra Limited is required to redeem preference shares out of the proceeds of fresh issue of shares made for the purpose of such redemption. So basically, fresh issue is also an option for me, or the profits which are available for distribution as dividend is also an option. So both A and B are answers. So then both A and B, this should be the right answer. Tejas Infra Limited is required to redeem preference shares out of CRR. The capital redemption reserve is used only for one purpose, that is issue of bonus shares. So basically this is not an option. So the answer would be again C, both A and B, profits as well as the fresh issue of shares. Then the last fourth point, while constituting a CSR committee, how many minimum directors are required to be appointed by Tejas Infra Limited? So whenever CSR provisions are applicable to us, we have to appoint at least 3 directors. Out of these 3 directors, at least one shall be a independent director. So looking for these answers, the first point states that in a company by CSR committee formed by Tejas Infra company shall have minimum 2 directors. That is not an answer. Shall be having 3 directors, out of which at least one shall be independent director. That is an answer for me, but I'll go through the other parts. 4 directors not an option, 4 directors not an option. So answer will be option number B, having 3 directors, at least 3 directors, out of which one must be a independent director. That's your first case study. Now by the time we have spent close to somewhere around, I guess, 4 or 5 minutes here. In the last 4 or 5 minutes, you might have understood how we should start reading the question. As soon as we get comfortable, and I don't expect you guys to read the question in this manner the very first time you are dealing with case studies. Once you have completed your 100% of syllabus, once you're done with your syllabus thoroughly number of times, every single point in and around your law must be remembered by you. Once you start remembering all the provisions together, then you'll be able to understand the case studies in a better manner. So before we come into this process, before we start practicing questions, my always suggestion would be go through the theory material as many times as possible, then start understanding the questions out of it, right? Now, the second case scenario, Greenfield LLP and Blue Wave LLP were 2 thriving businesses operating in the renewable energy sector. Greenfield specializes in solar panel manufacturing, while Blue Wave was known for its innovations in wind turbine technology. So there are 2 companies. One is Greenfield, which is into the process of solar panels, and second is your Blue Wave, which is into the wind turbine technologies. Both companies saw a strategic opportunity to join forces and create a more comprehensive renewable energy solution provider. So basically they're going into merger amalgamation. They decided to merge into a single entity to be called as, the new entity's name will be EcoFuture LLP. So we have 2 LLPs. They decided to merge with each other to be forming a single LLP called as EcoFuture LLP. To facilitate this merger, the management of both the companies proposed to a scheme of compromise and arrangement under section number 60 of LLP Act. They approached the tribunal to sanction the scheme, which involved transferring all assets, liabilities and ongoing legal proceedings of both Greenfield and Blue Wave to EcoFuture LLP. So everything is going on point. We have made an application to tribunal. We decided we're going to transfer all the assets and liabilities, which involves the process of merger amalgamation. So we have to now get an approval from the tribunal. The next paragraph. The tribunal reviewed the proposal and found that the merger scheme was designed for the construction and amalgamation of Greenfield LLP and Blue Wave LLP. The tribunal issued an order under section number 62, sanctioning the scheme and setting forth several provisions to ensure the smooth transition. That is, what were the conditions put by? All the assets and liabilities must be transferred, ongoing legal proceedings must be continued, and old entities, old LLPs must be dissolved without winding up. We usually do the, as we know, we dissolve an entity only after winding up usually. So after selling all the assets and liabilities, after clearing all the liabilities of the entity, then we go for dissolution. But this is one of the special case where we are not selling assets, settling liabilities, we are not winding up the entity, but we are still dissolving it, closing it by transferring the assets and liabilities to a new entity. So we have dissolution without winding up. However, a few partners of Greenfield LLP were not in favor of the merger. So that means we have dissenting partners who don't agree for the merger amalgamation. They dissented from the compromise arrangement. The tribunal provided specific directions to ensure that their interests were adequately addressed. So they gave conditions for dissenting partners. After the order was made, both LLPs had to file a certified copy of tribunal's order to the registrar within 30 days. Yes, they have to file the copy of order from the NCLT to the registrar within a period of 30 days. Unfortunately, due to some administrative delay, this filing was not completed within the stipulated time, leading to a penalty for both EcoFuture and its designated partners. Because the compliance activity, the liability will be on not all the partners but on the designated partners. Now let's get into the questions here. What was the main purpose of the scheme proposed between Greenfield and Blue Wave LLP? To dissolve? No, our intention was not to dissolve the entity. Transfer all the assets to a third party? No, we are not transferring to a third party. We are actually continuing the business activities. For reconstruction and amalgamation of LLP? Yes, that is one of an option. To liquidate the companies. Our intention was not to liquidate the companies, but our intention to join forces to provide a better renewable service provider. So just looking at the options also, the other three options are not reasonable in nature. So option C will be your answer here. What authority does the tribunal have when it sanctions a compromise arrangement? Whenever a compromise arrangement between companies are merger amalgamation have been authorized, has been an order passed by NCLT always has an option to come and supervise the process of implementation of compromise arrangement. And after supervision, if they're not satisfied with the way in which it is being implemented, they can always come and pass order for modifications. Even after these modifications are passed or without the modifications order being passed, if they believe that the implementation of this compromise arrangement is not practically possible, they'll ask the LLPs to be wound up. So there are three different options, three different authorities for the tribunal during the compromise arrangement. Let's go through the options here. Only supervise is not an option. I have supervise, modify and wind up. No authority? Absolutely not. We have authorities in it. Can supervise, modify and give directions for the arrangement? Yes, this is an option. Can dissolve the LLP directly without any conditions? We cannot dissolve it. We can dissolve it only when we feel that it is not able to be implemented. So the option is C. We can supervise, modify and also give directions whenever required. What penalty applies if an LLP fails to comply with the 30-day filing requirement? Now, I know most of you might have not learned penalties for all the sections, all the provisions of the entire syllabus. Obviously, it is not practically possible for you guys to remember every penalty out there. So, but whenever penalty comes in, make sure that you do a reasonable judgment of options given below. What happens if it is not filed? If it is not filed, whether I'll dissolve the LLP? Can I say it is a little overboard to dissolve the LLP if the documents are not filed? We have not violated the provisions. We have simply not filed certain documents to the ROC. So that is not an option. Fine can be an option and additional penalties can be an option. Suspension of business, revocation of tribunal. So option A, C and D are little overboarded, little reacting to the process of not filing certain documents. So based on that analysis also, the option would be B. If you are remembering the penalty number, that's very good. If not, start making elimination of MCQs, elimination of options to come up to an option. Even though you're not familiar with this particular question, this particular MCQ, you can still write the answer. It will be 10,000 and additional penalty for continuing defaults. Now, independent MCQs, look at this. Mr. X has resided in India for less than 182 days during the financial year 22-23. Now, whenever the provisions of FEMA come in, the main mistake I've seen students even at the final level do is they'll miscalculate the number of days, they'll miscalculate the financial year and get confused and write a wrong answer and come in. So, whenever my suggestion for FEMA would be, whenever question from FEMA regarding the residential status is asked, make sure that you write the facts of the question separately in the question paper, understand the question properly, then we'll come and analyze the options and everything. So in the financial year 22-23, his stay in India was less than 182 days. And he has arrived in India on 1st April to conduct a business. He comes to India on 1st April. So he comes to India in the financial year 23-24 for business activity, which happens to be a specific purpose. So even though his stay in India in the preceding financial year is less than 182 days, if he comes to India during the current financial year for a specific purpose, he will be called as a PRI, a person resident in India. So continuing the question, to conduct business and intends to leave business on 30th of April 2024. Now this is one of the major mistakes. This question has been asked multiple times already at the final level also, and one of the major mistakes people do is 30th April 2024 is not falling under the financial year 23-24. It falls under the financial year 24-25. In the financial year 24-25, Mr. X is going to leave his business activities on 30th April and plans to depart from India on 30th June. So after business also, he stays back in India till 30th June. What is Mr. X's residential status for the financial year 23-24 under the FEMA provisions 1999? So first let's get this clear. He is asking the financial residential status only for 23-24. For the financial year 23-24, I'll be checking the preceding financial year, that is 22-23, which is less than 182. However, he is coming to India for a specific purpose. Hence, for the financial year 23-24, he will be classified as a PRI. How many days did Mr. X stay in India during the financial year 23-24? Get this point? He came to India on 1st of April 2023 and he's going to leave India on 30th June 2024. So he has stayed in India for the financial year 23-24 for how many days? For the entire financial year, 365 days. That means the option is B, he's a resident, PRI, and 365 days. And one more thing, this is given only to confuse you guys. Resident but not ordinary resident. This is not something which is used by FEMA. This is something which is used by your Income Tax Act. Income Tax Act defines resident, non-resident, resident but ordinary, but resident but not ordinary. But FEMA simply states that we are gonna call them as PRI, PROI, person resident of India, person resident outside India. So don't get confused by these wordings. The option would be B, a resident, and his stay in India was 365 days. Next question. Apex Manufacturing is an industrial company based in India. Recently, the company found itself embroiled in legal issues concerning two separate offences under different enactments. So fine. The question is already been completed detailed itself. So what are they asking? They're having two separate offences under different enactments for a single offence, but two different provisions have been drafted. The first offence involving a violation of environmental regulations for which the company was prosecuted and fined, already prosecuted and fined. Subsequently, Apex Manufacturing was charged under a different law for the similar but not identical environmental violation. This is very important line. Similar but not identical. So we have an exception here. Whenever there is a single offense for which two or more enactments apply, only one of the enactment can impose punishments upon it. The simple rule is that if it is a single offense, there should be only single punishment, single imposing of fines and penalties. So whenever this provision applies, this has an exception that if at all both of the enactments are imposing penalties on a different ground, on a different reason or for a different purpose, then they can impose penalties on a combined basis. Both of them can impose charges upon the person. Now based on this sentence here, the reason why they are charging this penalties are similar but not identical. If they are not identical, that means they can charge twice for the same offense also. Continue the question. The first offense was under Environmental Protection Act for failing to dispose of hazardous waste properly. So we have to deal with the hazardous waste. We have to disinfect, dilute them, then leave into the environment. The second offense under the Water Act 1974 involved discharging untreated water waste into river. So there are two provisions. One, we did not discharge it properly. Second thing, we have discharged it into a water body, a river. Mr. Sharma, the company's legal advisor, consulted on the said issue. He determined the prosecution outlined in section 26 of General Clauses Act 1897 and article 20 subsection 2 of the Constitution of India, which protested which protected against double jeopardy. Comment upon the validity of the protection that is given to the Apex manufacturing. So, yes, valid because both involve environmental violations. No, they are similar but not identical. Not valid because the specific actions of legal provisions violated are different. This is an option. So, I would be looking for the answer not valid. So, going through the options, I find everything which is mentioned as valid. Only thing that is mentioned not valid is option number B. So right away, that's my option, that's my answer, option number B. And the last MCQ. Regal Textiles, a well-established fabric manufacturing company, has been operating under the Textile Regulations Act of 1980 for several decades. Over the years, various provisions of this act has been subject to interpretation. So they have been acting in this particular industry, textile industry, for many decades now, and over the years there is a problem in interpretation of by both the companies and the industry at large. Our company as well as the industry have interpreted a particular concept in a interpretation of a particular concept has been applied with. One such provision pertains to the definition of sustainable practices, which has been a point of contention. So there has always been a doubt on the word sustainable practices. Sustainable practices to include the use of organic materials and recycling waste products. This interpretation has been widely accepted and acted upon without any legal challenges. That means the word sustainable practice has been used as a process of organic material and recycling waste products for the last several decades, and no court or no law authority has questioned upon it. That means it has been used from a very long time. As soon as I hear this logic, I come across the word historical usage. Whenever some law, some provision of the law is interpreted in some manner, from a very long period of time, it is assumed that it is to be implemented in that particular manner itself. Recently, a new regulatory body has urged that sustainable practices should be strictly defined to include only carbon neutral processes, excluding the use of non-organic recycled materials. This new interpretation has created a confusion in the potential compliance issue of Regal Textiles. So we have a doubt now, which has a long adhered to the established understanding of the term. He prepares to argue that the long-standing interpretation of sustainable practices should be upheld. What principle will Mr. Kumar likely rely on to argue against the new interpretation proposed by the regulatory body? So, as we discussed, it is regarding the historical usage. Now, look at the other options also. The first option they quoted here is judicial activism. If you have at least read interpretation once, we know there is no word called as judicial activism. There is no word called as strict construction. There is no word called as prospective overruling. Even though you go through the MCQs properly with a positive mindset, even though you have not studied interpretation that good, but you can still come up with an option which is the right answer here, because other three options are not even ever heard about. So only option that you have a little familiar and similar habituated is your historical usage. That's your answer for it. So these are the MCQs we have discussed. Moving on to the descriptive part. Second part, your descriptive questions. Coming to the descriptive questions, first point. Prashant incorporated a one-person company, making his sister Priya as a nominee. Priya is an Indian citizen. She was born and brought up in Kanpur, that is India, basically. However, now Priya and her husband are leaving India permanently to stay with their son, who is settled abroad for the last 15 years. So they are going out of India on a permanent basis. Due to this fact, she is withdrawing her consent of nomination in the said one-person company. Take into consideration the provisions of Companies Act 2013. Answer the questions given below. So first thing, the question is asking about a one-person company regarding the nomination clause. The question is, if Priya is leaving India permanently, is it mandatory for her to withdraw her nomination in the said one-person company? So the question here is, first of all, we'll understand who is eligible to become a member or a nominee. The provisions of section, not required to quote the section completely here, at least understand the concept here. The provisions of one-person company state that if a person is satisfying three conditions, he can act as a member or nominee of an one-person company. He should be a natural person, he must be an Indian citizen, and the third provision was amended with the new wordings which state whether or not a resident of India. That means even though you're not a resident of India, you can still act as a member or a nominee of a one-person company. So is it mandatory for her to withdraw her nomination clause? No, until unless she holds her Indian citizenship. It is clearly stated that she is having Indian citizenship, but she is going out of India permanently, but they have never mentioned that she is losing her citizenship of India. So make sure that your answer also quotes this. If Miss Priya, if at all in the future loses her Indian citizenship, then she has to mandatorily withdraw. But as of now, because nothing is specifically cleared in this, if at all she is still a Indian citizen, though she is not a resident, she can still continue as a nominee of the one person company. In second question, in case Priya withdraws her nomination as a nominee to the one person company, whether Prashant can appoint his minor son Rushang as the nominee of the one person company. The question here is, a minor, can he become a member of a company? So on a general basis, a minor can actually become a member of a company where the company will give him benefits through the shareholding. So he can become a member of a company. But there's a slight difference in the concept when it comes to a OPC. For an OPC, we don't only expect the member or the nominee to bring in finance, but also to come and manage, bring in skill for the purpose of managing the business of OPC. Hence, we don't expect a minor to bring in skill to the business. That is the reason why the minor is prohibited from being appointed as a member or nominee of an one person company. On the other side, on the flip side, can a minor become a member of a company? Absolutely yes. But can he become a member or nominee of an OPC? That is not allowed, that is prohibited. So the answer is no, it's not allowed. Then question number 12. In the light of the provisions of Companies Act 2013, discuss the status of Gram PTE, which is a company registered in Singapore. Okay, fine. Where is the company registered? It is registered in Singapore. That means they are discussing about something called as a foreign company that is conducting online business through telemarketing in India without a physical place of business in India. It is also informed that for the telemarketing business in India, the main server is located outside India. So the question is entirely based on the definition, section number 242, where it states that foreign company means a company which is incorporated outside India but having a place of business in India either by itself or through an agent, physically or through an electronic mode, and conducts a business activity in any other manner. So what's the first provision to be discussed here? It is done in an electronic mode. So even though they're not having a physical place of business in India, if they're able to carry on business in India on electronic mode, it is still considered to be a foreign company. Is still considered to be a place of business in India. So here they have specifically mentioned that they are doing telemarketing, which is one of the explanations given by Companies Act regarding the electronic mode. And Companies Act specifically also mentioned that irrespective of where the main server is located, if they are able to do business activities in India through any electronic activity, that is either telemarketing, tele-education, telemedicine, any telecom activities or data communication activities or supply chain activities, all of them combined together will be added into the explanation of the word electronic mode. So what is expected from your answer is the definition of section 242 and the explanation about the word electronic mode, which clearly states the process of main server as well as telemarketing activities. So based on this, your answer would be yes, it is a foreign company. So we have to apply the provisions of chapter number 21 for this particular company. In continuance of point 1 above, Prism Limited, a wholly owned subsidiary company of Gram PTA, decided to follow a different financial year for consolidation of its accounts outside India. So basically, where is the company located? Get the facts clear here. We have a Prism company, a company called as Prism Limited, which is located in India, and we have a holding company, Gram Limited, which is located outside India. For the purpose of consolidation of its financial statements outside India, there is a possibility that Gram Limited, incorporated in Singapore, is following a different financial year. As per the provisions of Companies Act, the financial year is defined as a period which is ending on 31st March of every year. But there is a possibility that because the company located outside India is following a different financial year, it will be difficult for them to facilitate the process of consolidation. In those situations, the company located in India, if it is having a subsidiary or an holding company situated outside India, they can go make an application to the central government. Who is making application here? A company making application to the central government, requesting the central government to provide a different financial year which will be convenient for them to conduct the process of consolidation. Central government, after reviewing all the provisions and documents so submitted, central government may provide you a different year. Sometimes the year provided by central government might not be entire year, complete 12 months period, but it is still considered as a financial year. So basically, what would be your answer? Make an application to CAG, get an approval from CAG for a following of a different financial year for consolidation purposes. Then question number 13. XYZ Limited, a prominent manufacturing company, is in the process of appointing a new auditor for the upcoming financial years. Mr. A is a renewed auditor being considered for the role. During the due diligence process, the following details came into light. Mr. B and Mr. A are partners of ABC Co. Mr. B has taken a personal loan of 4 lakhs. So basically, he's been indebted. So indebtedness is created here. As soon as I see the word indebtedness and auditor, will come across the section 141, subsection 3, clause D, subclause 2, which clearly states that either the auditor himself or his relatives or his partners shall not be having indebtedness with either the company or holding company, subsidiary company, associate company, or the subsidiary of the associate company. Basically, all the group companies shall not be exceeding 5 lakhs. If at all it is exceeding 5 lakhs, they are disqualified as per the provisions of 141 subsection 3 clause D subclause 2. So the partner of the auditor is already having an indebtedness of 4 lakhs, which is within the limit. And second part, Mr. A, relative of Mr. C has an outstanding Mr. A's relative Mr. C has an outstanding debt of rupees 2 lakhs with DEF Limited, an associate company. As we have discussed, it doesn't only mean that the company in which you are to be appointed as an auditor, it includes all the group companies. So even though it is a subsidiary company or an associate company, we have to add up everything. So 4 lakhs of debt for the partner plus 2 lakhs of debt from the relative, from subsidiaries and associates, all combined together sums up to be an amount of 6 lakhs. So we have to clearly explain in the answer that it is 6 lakh rupees, which is above the limit specified. Hence is qualified or disqualified. Disqualified to act as a auditor, hence is not allowed to be appointed. So the question is discuss about his eligibility. So we have to clearly mention that is ineligible to be appointed as an auditor for this particular company. So moving on, next question. Question number 14. OM Limited served a notice of general meeting upon its members. The notice stated that the following resolutions will be considered at the meeting. Fine. Resolutions to increase authorized capital of the company. We have to increase the authorized capital of the company. And the second thing, appointment and fixation of remuneration of Mr. Pramod as a statutory auditor, for appointment of such person as well as fixing the remuneration of such person and increasing the capital. These are the two major things which will be discussed in the general meeting to be conducted and for which the company has already served a notice. Good. Then a shareholder complained that the amount of the proposed increase and the remuneration was not specified in the notice. Is the notice valid? Now, this concept is about the logic of explanatory statement, section number 102. Whenever company sends a notice of general meeting, along with the notice of general meeting, they should also send an explanatory statement which explains all the facts and the circumstances, all the meaning, scope and implications of the transactions to be entered in the general meeting. But we have section 102 starts with the logic of defining business transactions into two categories: ordinary business transactions and special business transactions, and clearly states that this explanatory statement is something which is required only for special business activities. These two activities, not being the ordinary business activities, have to be annexed with a explanatory statement and have to explain every single fact about it, so that the shareholders have a proper understanding of what will be dealt in the general meeting. They'll do their background research and come informed to the general meeting. Because the explanatory statement did not contain the specifications of the contract, basically the explanatory statement is invalid, hence the notice will also be considered as void. I have to clearly mention that it is void and the meeting will be void. If at all any resolution is passed in that particular meeting, that will also be considered as void. The next question, question number 15. K Limited is in its first year of incorporation maintained its books of accounts under single entry system of accounting. Is it permitted under the Companies Act? So we'll quote section number 128, which states that every company has to prepare books of accounts for every financial year, which must be satisfying two accounting principles. It must be based on accrual basis and it must be on a double entry system. And the Companies Act does not provide any type of options here. It is mandatory that it must be prepared only on accrual basis and only on a double entry system. So K Limited preparing its financial statements in single entry system is not acceptable by the provisions of section number 128. State the persons responsible for complying the provisions regarding the maintenance of books of accounts, etc. of a company. So this is one of the important penalties under Companies Act section number 128, which states that if the provisions of section 128 have been violated, there will be 4 different people who are held liable for the process. First, the managing director. Second, the whole-time director who is in charge of the finance activities, and the CFO, Chief Financial Officer, and any other person who is authorized by the board of directors. These are the 4 people who will be held liable: the managing director, the whole-time director in charge of finance, CFO, Chief Financial Officer, and any other person who is authorized by the board of directors for tackling these provisions of section 128. All the 4 persons will be held liable for this non-compliance of maintaining the provisions in single entry system. The next provision is ABC Limited, a company that has been operational for 2 years, that means it is already in incorporation for 2 years, was incorporated with a submission of false information and suppression of material facts. The company's founders, Mr. X and Ms. Y, provided incorrect financial statements and concealed significant liabilities during the incorporation process. So what happened? They submitted certain wrongful information to the ROC for the purpose of incorporation, and ROC, because they're doing the verification process on a prima facie basis, could not detect the false information which is submitted to ROC, and the company got incorporated, and it has already been in operational for the last 2 years now. This misrepresentation was recently uncovered during the internal audit initiated by the company's new CFO, Mr. Z. Upon discovering these fraudulent actions, Mr. Z has filed an application to the NCLT, explain the provisions of Companies Act in respect of where a company has been incorporated furnishing false information. So there are 2 things here to be understood. We'll bifurcate the logics. If at all we submit false information for the purpose of incorporation of a company, and ROC is actually able to find them during that prima facie verification, ROC will cancel that application submitted and will not be incorporating you as a company. But if ROC fails to detect all such fraudulent information, false information so filed, they will incorporate you as a company. Once the company is incorporated, we cannot directly close the company, wind up the company every single time, because the creditors of the company are already created, shareholders of the company are already created. There are huge number of employees who are depending on the company. If at all we close the company as and when, because of this false information, all the people connected with the company will be affected. Hence, the power will be given to NCLT, and NCLT can pass an order as they deem fit, which includes one of these orders, either increasing the liability and changing the liability of the members from limited to unlimited, or asking the company to be merged or amalgamated with another company, asking the company to go into winding up, asking the company to wind up this business and start a new business activity, or do such other activity as the NCLT deems fit. There is no specific answer for this particular question. We can actually expand this as much as possible. This is basically an inclusive definition here. Then moving on to your LLP questions here. XYZ LLP was registered with the Limited Liability Partnership Act 2008 with a name that was later found to be identical to an existing company's name, XYZ Private Limited and OPC. This similarity was not noticed at the time of registration. So what happened here is we got incorporated as an LLP with a name which is identical, or which is actually exactly identical with an existing company. So it is not our fault that it was identical with an existing LLP. We made application to ROC as per the provisions of LLP. ROC failed to verify that this name is already been taken up by another company, and we got incorporated with the same name. But after incorporation, it is not allowed, it is not possible for us to continue in the same name. Hence, because it was the fault done by the authority, not by the LLP or the partners, the law states that this time the action will be taken by the central government, where central government will not impose you penalties, central government will not impose you any punishments, etc. But central government will basically state that we are gonna ask you to change your name, and the change in the name must be happening within a period of 3 months. Explain the provisions of LLP Act in the respect of the following. if the name is identical. What shall be done? Central government on a suo motu basis or on a application made by any registered trademark owner, proprietor will come and pass an order asking you to change the name and asking you to change the name within a period of 3 months. Once you follow all the procedures of LLP on how to change the name, we after the change in the name have to submit documents to the ROC within a period. This is a special point. It has to be remembered specifically. It has to be submitted to ROC within a period of 15 days. Once it is submitted to the ROC prepares the new certificate of incorporation containing the new name and will be issued back to the LLP within a period of 30 days from the date of submission of these documents. And the consequence that if at all you have not changed your name within the set period of 3 months, the central government may allot a random name for you and ask you to continue with that particular name. So that is the formalities regarding the registrar and as well as the concept of identical name. Then next provision, Mr. Chagan Lal is an importer dealing in luxury perfumes. Recently, a new enactment was passed which imposes a duty of 15% of the value of luxury goods, including perfumes. Now, Mr. Chagan Lal has approached you to explain to him the provision relating to the duty to be taken on a pro rata in enactment. So, basically, we'll take a proportionate basis of duty to be imposed. If the value is greater, if the quantity is greater, we'll also impose a greater amount of duty. If the value or quantity or measure is lower, we'll also impose a lesser amount of duty here. The same provision, General Laws Act, also help him calculate the amount. So we have to calculate the amount. So what's the total bottles he has brought in? 100. Each has a value of 50. That means he has brought in a total value of $5,000 into India. And for each amount of money brought in, we'll be imposing a duty of 15% here, which will come out to be $750. So he'll be having to pay a duty of $750. Basically explain what is pro rata basis, explain the provisions that minimum what is the how a duty will be calculated, and actually give this calculation and highlight this process of $750. Should be fine enough. Then question number 19. Imagine you are a legal advisor of a company drafting a contract. One of the clauses in the contract state notwithstanding anything contained in any other provisions of this agreement. So we know the notwithstanding agreements where it is basically a conflict between the provisions within the law, and notwithstanding is something which states that keep everything aside, I'll create a law which is not which is against everything which is already explained to you. That means I'm creating a superior law. This notwithstanding clause basically considers itself as superior to the other provisions of the act which will prevail. Hence, the notwithstanding act will be basically considered for the purpose of interpretation. The company reserves the right to terminate the agreement without notice if there is a breach of confidentiality by the employees. Explain to the management of the company that the meaning of the non-abstain clause in legal document and its effect on overriding the provisions with reference to decided law. Basically mention the harmonious construction here, explain the process of notwithstanding, abstaining clause, superior and inferior laws, and explain that superior laws will prevail over the inferior laws if there is no harmony possible in the process. That's your process for notwithstanding. Then the last question is, Mr. Arjun, an Indian resident, has been working abroad for the past 10 years. So he is basically an Indian resident today, but he has been working abroad for the last 10 years. During his tenure abroad, he acquired. So let's get the facts clear. Today he is a PRI, but in the past he has been working outside India. During this tenure abroad, he acquired foreign currency and held investments in foreign securities. Foreign currency and foreign securities are held when he was a PROI. He also inherited a property located in New York from his late grandfather. So inheritance of property located outside India, who was a non-resident Indian. So his grandfather was a PROI. From a PROI, we have inherited a property situated outside India. After returning to India permanently, Mr. Arjun wishes to understand the provisions of Foreign Exchange Management Act 1999 regarding the ownership and utilization of his foreign assets. Basically, this is a provision for, first of all, capital account transactions under section number 2 clause E, which states that today he is a PRI and he is altering assets or liabilities, including the contingent liabilities situated outside India of a PRI. So basically, it's a capital account transaction, and following the definition of capital account transaction under section 2E, we have given clarifications on section number 6, Section number 6, clarifications, clearly states that we have given a possibilities in which a person who is a PRI can hold foreign securities, or a PROI who can hold Indian securities or currencies. So going to the specifications here, we have section number 6, clause number 4, which states that a PRI can hold, own, transfer, or deal in foreign securities, foreign currency, or immovable property situated outside India if the same was acquired, held, or owned when he was a PROI. So he acquired them at what point of time? When he was a PROI, and today he is classified as a PRI. The law states that it is absolutely allowed for him to continue holding or dealing with those properties, or any kind of property which is inherited by a PROI from a PRI from a PROI is also allowed to be held, which is explained under section number 6 subsection 4, which talks about the clarifications given on the capital account transaction. So that ends your RTP. So whatever we have discussed in this RTP, all the 10 MCQs and the 10 questions, we have probably taken a time of say 1 hour for the explanation purpose. If at all you feel at any point of time we were a little quick, please do stop the video and make sure that you get comfortable with the questions there. So and again, one more thing, we'll actually come up with another video where I'll be explaining on how to present the paper, how to write the paper. There are questions where it has multiple verticals in it. There are questions which has a single sentence to it. So we'll be coming up with a particular question, paper presentation video in the coming future, which will explain you on how to do it. So that's all for this video, guys. Let's wrap it up in here. Hope your preparations are going very good, and make sure be motivated, be determined about the results. Don't expect results out of it, but be consistent with your processes. So trust the process, you'll definitely see results in the very coming future. So all the very best, complete this, and if at all you have anything from my side expected, so you can please do leave a comment on the video, whatever you require, that is revision classes or any particular conceptual explanation. I'll come up with these videos. Thank you guys, thank you so much.